persuasive and well-worded talk on a very interesting paper. I'm Chris Van Eyck, and I will be acting as the discussant between these presentations to try and draw out some themes, and then we will have a question and answer session that the audience can submit to at the end to all of our panelists. So first I wanted to ask you, sort of the themes of my questions in general, I guess, would be capacity as a concept. I have to admit I'm not a specialist in refugee law specifically, and so correct me if I'm wrong or sort of don't understand something important. But my understanding is that you're looking specifically at situations where the state lacks the capacity to even assess refugee or migrants, sort of the amorphous mass that term includes. But I'm wondering, so in the sense of just for refugees, obviously there is some provision in the Refugee Convention that discusses equal treatment of between nationals and non-nationals, right? Article 20 and following. But I can understand that perhaps the problem more is that when there are so many people, it's just states can't act in a way that kind of makes that division. But see, to me, there's the problem that I get to, the sort of thorn that nags at me here is obviously there still is a set of rules in place for trying to prevent obligations not to persecute, which is the defining feature of refugees in general. Human rights law set standards for that. And then on the other hand, migrants obviously have their own themes in terms of, they could be fleeing anything from actual violence from the state to climate issues, and causation is sort of hard to find there. So what do you propose, I guess, in terms of like addressing that divide, mixing these two legal regimes?
I think the biggest feature of the Refugee Convention at the moment is that it takes at the very first instant, a state can't refuse asylum just because it says, I don't think you are a refugee. That determination doesn't happen at the first instance, at the entry point. So that distinction between, as you said, the various categories that you've pointed out, that comes up later. Mm-hmm. But for that period, the state is still required to sort of host the person who it may or may not consider a refugee, but for all intents and purposes is a refugee because of the classification at the entry point. Having said that, that imposes a burden on the state in any case, because they do have to use their resources to take care of those people. Now, because they have to use their resources, they're diverting their resources, which could have been used elsewhere, to these people. I'm not saying that's a bad thing, because of course there is equality that's envisaged in the human rights treaties and all of the documents. But you must understand that human rights can be distributed equally or equitably only when there are sufficient resources to distribute them equally. When there's no resources, the problem that then arises is you have to decide which rights to prioritize and also which groups to prioritize. And in that prioritization, I've noticed that most states just consider refugees the last population that has to be prioritized. But in the model I propose, if there is some sort of burden sharing, and it's not something that comes out of an ethical conundrum, like where the United States decides, okay, let's give US aid because we're benevolent. But it comes out of, we've caused this because, like, let's say, for example, there are situations where there's persecution of the Rohingyas in Myanmar, there's persecution of the Uyghurs in China, and there's persecution going on around the world, where there is a sense of a legal obligation that you should contribute to the flow that you have caused. Now, causation is a different question altogether. But if a sense of legal obligation is created, then I would say that it makes the refugees themselves more likely to get access to their rights than at the current moment. Whether they're refugees or not is a different question altogether. I would say all of those people end up getting access to rights that they require.
Okay, if I could just maybe ask one more short follow-up. It seems, I'm intrigued by this, because it seems like you're trying to address aptly, I think, the empirical reality of how this is going on and the problems with the system that we're seeing. And it's quite interesting to me, because obviously, I mean, if and a state treats a refugee in a way that is less so, or gives them fewer resources than that of its nation state. I mean, the doctrinal international lawyer says, cool, that's an Article 20 violation. There's a dispute settlement clause. ICJ, I mean, seems to be a route. Or regional human rights courts, for instance, could start kicking into action. But obviously, that's not solving the problem that we're seeing in the news. I guess my question really is, is it an issue necessarily with the effectiveness of, or you talk about incongruity within human rights quite a bit. Is this an issue of contradiction within the idea of human rights, or is it one just of actual effectiveness and enforcement of them? Is this an issue if there's not enough courts to go to, or is it an issue with the theory itself?
So I would start off by saying it's certainly an enforcement issue, but there's a deeper issue beyond the enforcement issue. As you've rightly identified yourself, that this is what I am saying, which is there is a deeper issue because the human rights treaties, let's look at the core treaties, the ICCPR and the ICESCR as the two covenants, one of which says you have minimum core obligations to satisfy, and then there's another set of obligations that have to be progressively realized. When you have all of these obligations, what you're doing is you're inherently prioritizing certain rights. So you may have cultural rights. The right to culture is certainly a very important right because for whatever reason in the ICSCR, it is guaranteed to various populations. But then there are situations where the right to culture does end up coming in conflict with the right to life, which is basically the right to food and water. So the example I give you of this conflict, this inherent conflict that exists in the human rights framework, which creates problems of prioritization, is let's take the example of the Aswan Dam. When the Aswan Dam was built, there were certain monuments that got submerged. And this was in Egypt way back when. There was a huge hue and cry at the time about the rights to culture of the local populations. The same thing happened in Turkey when the monuments of Hasan Kaif were needed to be raised in order to enable certain populations to grow food and things like that. So you have the right to life, which is enabled by food, enabled by water. The Aswan Dam was built so that the populations in the area would have access to water, would have access to electricity and that sort of thing, which would enable their right to life to be better off. Now, what I'm saying is when you have two rights in conflict with each other, the best way to go about it is to use the proportionality approach, which was what was done in Hasan Kaif and in certain other situations, where they've moved the monuments from where they were, the ones that could have been moved. So they've done minimal interference in the right to culture so that the right to life could be ensured. I propose in the context of refugees, I propose that there should be minimal interference in the right of the refugees. Because I admit they may not be citizens, they may also be in the minority, but they do have rights. So you recognize that they have rights and you find the solution that is minimally interfering in their rights to then go and distribute the scarce resources to your local population so that you can ensure everybody's rights are met to the best possible way that you can meet them. Otherwise, if you have a rich person living along with the poor refugees, and this rich person is living rich because he lives on benefits, he lives in a state where, not on benefits, but what I mean is this rich person stays rich because he benefits from all of the state's services, while the refugee doesn't have access to basic food and water because he lives in a refugee camp that the state just is unable to fund. That creates a problem. So you've got to do something in the lens of proportionality that I've proposed in the paper. And I hope that answers your question, but that's the inherent tension that I see in the human rights framework that is a bit problematic in refugee law.
Thank you. I think I'm going to hand the floor back to Neve to move on to our next speaker. And then please, audience, feel free to ask questions in our chat at the end.
That's great. Thank you so much, Pavan, for such a thorough consideration of a rather tricky conundrum in refugee law. And thank you, Chris, for your interesting questions. Our second